rejecting, then we'll pick a jury on the case Monday, which is the 13th. Is that correct, Ms. Anderson?
Yes, sir.
Okay. What's the situation, Mr. Davidson? Does the defendant, Mr. Bledsoe, wish to accept the offer or reject the offer?
Judge, I was able to, even though I can't visit him at the North Jail because of the quarantine, I was able to leave over 500 pages of discovery for him to go through. I just need to know if he's had an opportunity to go through those pages, of the 500 pages of discovery I left with him to go through.
Well, how long is this case? You just say you just left him 500 pages of discovery. When did you leave those 500 pages?
I left those with the jail last week. The reason it was last week is because those are CPS records, and those CPS records were not given to me until I don't know the exact date, but they were recently given to me. I shared those with Mr. Bledsoe. I just need to know if he's had time to look at those.
Well, so you're asking, okay, let me explain this to you, Mr. Bledsoe. You're on Zoom. Your attorney's asking you a question. You can answer it if you want to on Zoom.
Okay. So
Hold on. I'm sorry, Judge. It looks like Christy got kicked off. We need to put on hold for just a moment. Okay, it looks like we have Christy back.
All right, just to be sure there's no breakup in it, we're continuing on the record, cause number 2410114-21, State versus Christopher Bledsoe. I can't see her right now, but I know Ms. Anderson's on the screen. My probation officer's on the screen. So I suppose Mr. Davidson's asking you here on Zoom, Mr. Bledsoe, if you've reviewed the 500 pages of discovery in the case he turned over to you last week. Well, that's basically an attorney-client matter, but if you want to answer it, you can.
well, sir, they did allow me to briefly go through it. They didn't give me enough time to really sit down and go through it completely, entirely, but I was able to go through it briefly, and there's a lot of stuff in there that's just made up.
Since that's the way you feel about it, since Mr. Davidson just got it to you last week, I don't know when he got it, I suppose last week. I'm sure he gave it to you as soon as he got it. Should have. The bond in your case, the $100,000 surety bond, it's a state jail felony. You're sitting in jail. That's where you'll be until the court gets the case, until you and Mr. Davidson are ready. Basically, when Mr. Davidson's ready, I don't know when it'll come up again, is what I'm telling you. That's been set for some time. How long, Ms. Anderson? Well, I can't see Ms. Anderson.
Yes, sir. I'm here.
Ms. Anderson, I can't see you. I'm looking at this meeting as being live streamed, but how long has this case been number one on the docket?
It's actually number 3 on the docket for September 13th. And let's see, it was on the August trial docket, but we did not reach it.
All right, so
We had a discovery issue, and that's what
Marguerite doesn't go home.
was referring to, was we
Trying
had
again.
outstanding CPS discovery. But now those are the records that he delivered to Mr. Bledsoe, I believe, in jail.
All right, so have you filed a written motion, Mr. Davidson?
Judge, I will do that before 5 o'clock today.
Understand this, you understand it, Mr. Davidson, and I understand, I want to be sure you understand it, Mr. Bledsoe. This will not keep your case from going to trial. All right, now, I'm gonna let Mr. Davidson file one motion for continuance, as we call it, and I'm gonna give you a new trial date. Mr. Davidson can come over there and meet with you, whatever the jail will allow on that 500 days of discovery. But what you got to understand is you're on a $100,000 surety bond on the state jail felony. And that's, it's up to you whether or not you accept the offer. The other side of this road is the state doesn't have to leave that 5 deferred offer out there. They can reject it today. It's off the table. The case goes to trial before a jury. So do you understand that also?
I believe so.
All right, because in other words, they've made Mr. Davidson the offer. Apparently, he got this discovery last week. So this is a number 3 case on the dock. And do I have a written motion from you, Mr. Davidson?
I'll file one before 5 o'clock, Your Honor.
Well, then the answer is no, I don't, but you'll have it filed before 5 o'clock. So I'll grant it to the next jury trial setting. I don't know myself right now when that is. Ms. Said I don't have anyone in here, so I don't know. Do you know when the next trial setting would be, Ms. Anderson?
Well, the next date after that is September 27th, but I think we'd have to ask Ms. Freeman or Ms. Langston, because I don't know if those dates are already full or what, Your Honor.
They're probably full. What happens when we don't reach them is the defendant sits in jail. I know Mr. Davidson knows that. He's got some other cases, and if they're not reached because the defense isn't ready, I'm like, he's going to be under $100,000 bond till this case gets to trial. Mr. Davidson wants to file a motion for a speedy trial that'll move it up, but I don't have one right now. And now he's going to file a written motion. I always grant the first written motion for continuance when I can. I'm going to get a new setting on the case.
I'll file it before 5 o'clock.
This one will roll to September 27th.
Mr. Davidson, I'm sure you will put in your motion why this man's sitting in jail under $100,000 bond on a state jail felony and we can't get the case to trial.
Yes, sir. We're gonna be set, I believe, on September 27th.
May I ask a question?
You could ask me.
Hang on a minute. This is what happens when one side or the other is not ready, because you don't need to be asking questions. I don't know what you're going to ask, but there's a court reporter taking down right now everything you say. It's a part of the official record. So I can tell you this, on the status of this case with Mr. Davidson filing a written motion for continuance, it's not going to trial next week. I'm going to give it a new trial setting. Then you need to talk to Mr. Davidson before you get on. I don't know what you're going to say. That's the problem. And I can't give you advice. So you just have to ask Mr. Davidson whatever you want to ask. He's short, but I'd recommend you not ask it on I don't know what you're going to ask. The state's prosecutor sitting down there going to have a record of everything you say. So you need to wait and talk to him in private. What's our new setting date? I believe you knew it, Ms. Anderson.
Ms. Freeman confirmed it will be September 27th.
All right, case is set number 1 on the trial docket for September 22nd. The first motion for continuance has been granted. The second one is not discretionary. Get down to that second one, Mr. Davidson will be, I haven't seen the full docket, but it's likely he'll be at the top again, probably headed to the top on most cases, on most dockets now. So this case is going to be set number 1 unless I've got a case behind it where the defendant has been in jail longer.
Yes, sir.
I don't know. We usually try to set them by the numbers. Mr. Davidson knows.
Yes,
so Mr. Davidson's written motion for continuance, which he just told me he'd get to me before 5 o'clock this afternoon. I'll sign the order. And Mr. Davidson's motion will have in it the reasons, which is the discovery. And then I'll sign the order granting the motion for continuance. The defendant will be continued in custody in jail under $100,000 surety bond with an offer of 5 years deferred adjudicated probation on a state jail felony. But
yes,
that's the defendant's decision, and Mr. Davidson's, really it's the defendant's. So the court is granting once I get the motion for continuance, which will be sometime before 5 o'clock this afternoon, I'll sign an order which will be attached to the motion for continuance, grant the motion for continuance over to what date, Ms. Anderson?
September 27th.
I'm sorry, I lost you a little bit. September 27th.
Yes, sir.
All right, court will grant the motion for continuance. I'll sign the order when I get the motion. The order prepared by Mr. Davidson will say the motion for continuance is granted and the case is set for trial on Monday, the 27th. Defendant's continued in jail under the $100,000 bond. Offers 5 deferred. Now, of course, I'm sure Mr. Bledsoe, Mr. Davidson's explained to you this, so that the state can withdraw that deferred adjudication offer on this state jail. They're not bound to leave it out there. You understand that?
I understand.
All right, we're in recess.
Thank you.
Okay, if you'll let them know we're ready for Shuttlesworth.
Yes. Like you're sitting in the courtroom.
Okay.
All right, we're on the record in cause number 241-1253-20, State versus James Shuttlesworth. Possession of controlled substance. Indicted as a third-degree felony. There's an enhancement paragraph alleging a prior conviction for burglary habitation. If that was proven or stipulated, the third-degree felony 2 to 10 would be increased to a range of a second-degree felony, not less than 2 to more than 20. Mr. Shuttlesworth's on the Zoom with his attorney, Mr. Davidson. Ms. Anderson's present on the Zoom along with Marcel, the court's probation officer. Is this case on the docket, Ms. Anderson?
It's just set for plea today, Your Honor. It is not on the jury trial docket yet.
Wait a minute, set for a plea today?
Yes, sir. I mean, I'm not saying we have plea papers. I'm saying this is the plea
Okay.
paper docket date.
Well, let's see, his bond's $150,000 surety bond. I don't have any plea papers, so it was set for a plea today, so apparently it's not gonna be a plea, so I suppose the defendant will be continued in custody of the jail. He's got a $150,000 surety bond. Is that where we are, Mr. Davis? Because I'm not accepting any offer up close to trial. The state has to get ready, you have to get ready, and this is a possession of a controlled substance, third degree alleged if the enhancement's proven up to a second degree. Have you made an offer on this, Ms. Anderson?
Yes, Your Honor. The offer was originally made last October when the discovery was made available. I'm not sure where all Mr. Shuttlesworth has been since then. He was not rearrested and brought to, or didn't reappear and get rearrested in Smith County until sometime in the beginning of July.
Well, let's see, there is a capias here. Capias, cause number 241-1253-20. So it would appear that there was some type bond violations, bond conditions, or for some reason the bond wasn't. Well, the bond on the back of the indictment is $150,000. Do you know what happened on this, Ms. Anderson?
No, sir, I don't.
Hang
I
on,
don't know.
just a second, I'll tell you. Well, let's say I have a bond violation report. The defendant reported to his weekly office visit as ordered October 22nd, 2019, tested positive for methamphetamine, admitted to consuming on or about the date of October the 20th, 2019. Please see tax documentation. That was from Caesar Barron, Jr., supervision officer. It was a bond violation report. Court ordered a warrant for the arrest of the defendant, set a new bond at $50,000.
And then I think after that, Your Honor, in September, he then failed to appear at arraignment and there was another warrant that was issued. Or maybe it's just been the single warrant. I'm trying to.
No, just hang on a minute, you're right. Looking up towards the front of the file, there's an alias capias bond violation on State versus Brian Shuttlesworth, address down in Troop. That was, that $50,000 bond was tripled. And another case, because alias case, arrest warrant was issued for with a bond set at 150,000 with new conditions, no PR bond violation. So at any rate, bottom line is the bond right now is $150,000 on the indictment. So what are the announcements on this, Ms. Anderson?
Your Honor, we had, there was an offer made originally of 12 years confinement in the institutional division. Mr. Davidson, I think he's communicated that to his client, but I think Mr. Davidson has also made some communications with Mr. Gerald, so I'm not sure where things stand today.
All right, what Mr. Davidson had some conversations with who?
Brian Gerald.
Oh, Brian Gerald. Okay, what's the situation, Mr. Davidson?
Judge, that's all correct. I have had communications with Mr. Gerald. I need additional time to flesh out those communications. I don't need a lot of time. If we could just have whatever the next docket setting is, that's correct that I have not had a chance to speak with Mr. Shuttlesworth because he's been in the North Jail. But I'm trying to get to see him as soon as I can.
What was our next docket, Ms. Anderson, that we just put one of Mr. Davidson's on?
Well, that one was for jury trial. We put him on September 27th.
Okay, so what, do you know, I don't have Tabitha in here, I probably could ask her, when is the next plea docket?
Your Honor, I don't know when the next plea docket is.
Well, let me see if I can find out. Hang on just a minute.
The next one that we can set this on is going to be I can set this on Tuesday, October the 19th at 9:30.
Tuesday, October the 19th at 9:30.
Yes, sir.
That'll work, Your Honor. Thank you.
Well, I didn't say I was going to do that yet.
Oh, well, I'm just hoping.
Tuesday, October the 19th at 1:30. Is that it, Tabitha?
Yes, sir.
All right. The defendant is continued in jail on the $150,000 surety bond. And court will, is that a plea docket you're talking about, Tabitha?
Yes, sir.
October 19th?
Yes, sir.
At what time?
9:30.
What day is that day of the week?
It's a Tuesday.
Tuesday, October the 19th at 9:30.
Yes, sir.
Case is set for a plea on that date. Defendant is continued in custody on the $150,000 surety bond. If the case is not a plea, on a plea agreement on that date I just put into the record, agreed to by state and defense. If it's not a plea on that date, it won't be a plea. It'll be a trial by jury. I'm not going to push it back again. So you understand that, Mr. Davidson?
Yes, sir.
You
And if I talk with Mr. Gerald and we can get this worked out before that date, I'll inform the court and we'll ask for an earlier setting.
Well, that would be good if you can talk to Mr. Gerald, because if it's not a plea by that day, he's going to go he'll be right at the top of the next trial docket. So you need to talk to Mr. Gerald and let Ms. Anderson know.
Yes, sir.
Set for a plea on that date that Tabitha has. Yeah, you got the date, Ms. Anderson.
I do, Your Honor.
All right, set on that date, continued in custody on the $150,000 surety bond. Set for trial on the date announced by the court. What do you have down as the trial date, Ms. Anderson?
I don't have a trial date. I just have the October 19th plea docket.
All right, it's on the set on the October 19th plea docket. If it's not a plea on the October 19th plea docket, the court will not accept a plea after that date. So it's not a plea, the defendant will remain in jail under $150,000 bond till it gets to trial. Because if it's going to be a plea, looking at the charge, no reason why it can't be a plea on that date just set by the court. That's up to state and defense and the defendant. October the 19th, 9:30 on the plea docket for that date. Defendants continued in custody on the $150,000 surety bond.
Let's go see. I'm waiting to see who they have next at the jail, Judge.
That's fine. Well, that's all right. We can wait.
Okay, what is your name? Sir, what's your name?
It's James Howard.
Thank you.
All right, court's calling cause number 241-1062-21, State versus James Caleb Howard. On indictment charging state jail felony, possession of a controlled substance, meth, in an amount of less than a gram. However, the indictment has two priors alleged. Second paragraph alleges a prior felony conviction for manufacture, delivery of controlled substance. Last paragraph in the indictment alleges another felony conviction, possession of controlled substance. Bond on the indictment is $15,000 to finish before the court. I don't have any plea papers on this one either. So, is this what do you got on this one, Ms. Anderson? Obviously, this is not going to be a plea. I don't know why we're calling plea docket, except to get them over on the trial docket. Probably be good for the court. Just to put them right on over on the trial docket, but go ahead, Ms. Anderson.
Your Honor, the offer for Mr. Howard is 5 years confinement in the institutional division.
5 years. What's the full range on this one, Mr. Davidson?
Judge, it's a,
See, it's a state jail enhanced to a third.
it looks like the range of punishment is 2 to 10 and a fine of up to $10,000.
That would be it if the two priors are proven. 2 to 10, fine of up to $10,000. I'm sorry, Ms. Anderson, did the state make an offer on this one?
Yes, sir. The offer's 5 years.
All right, how long ago was that offer made?
That offer, this was one of Ms. Autry's cases, so that offer was not made until August 26th.
Okay, Mr. Davidson, does the defendant wish to accept the offer for 5 years to do with credit?
I don't know, Your Honor. I have not had an opportunity to speak with him.
Okay, let me make this real clear. If you want to talk to him and you want to keep this open, it's going to be kept open for a very long period of time, short period of time. I can't go to plea dockets and just call cases to find out they're not going to be pleas or no resolution. So I guess, do you want this on the trial docket?
No, Your Honor, I want to be able to talk with my client.
Okay, what do you need to do to go talk to him?
I have to schedule a Zoom meeting and see when the jail will have availability for me to do that.
What units, where in the jail is he?
He's out low risk.
He's at low risk?
He is.
Tabitha, can you hear me?
Yes, sir.
Call low risk this afternoon. Tell him I need a Zoom set up between Mr. Don Davidson and this defendant, who would be Mr. James Howard. The estate's made an offer. I believe Mr. Davidson said it was 5 to do. It's 2 to 10, or Ms. Anderson said your offer is 5 to do, Ms. Anderson.
Yes, sir.
If the priors are proven, it's a third degree, 2 to 10. Tabitha calls, or Denise, one of y'all call state jail, see if they can go ahead and get a Zoom set up with this defendant.
Judge, I had him a Zoom set up at noon today.
While a Zoom was set up at noon today,
Yes, if he's at low risk.
he's at low risk.
I had a
What,
Zoom set up at noon and Mr. Davidson did not call.
I did not receive an invitation like I usually do from low risk when they have me set for a Zoom. I checked my email, no invitation was given to me.
I'll handle it personally. I'll get a list of all your settings and I'll be sure you get plenty of notice because we're just pushing these cases back and I know how to handle it. I'm trying to give you as much time as I can. So you need to head on out to low risk. And I just told Tabitha to call low risk to set you up a time, however you need to do it, where you can Zoom with this defendant because there's a 5 to do offer out there on a 2 to 10 case. And the defendant's just remaining in custody. So he's out at low risk. Can you get out there? Can you get your Zoom done right away, Mr. Davidson?
Yes, sir. I'm available anytime. I can't call them. They have to call me.
That's what's getting ready to take place. They're going to call you and give you the date and time for your Zoom. Be there where you can get at this Zoom in. I can find out whether or not this defendant's going to take the 5 or reject the 5. Once if he rejects it, it just goes over onto the trial docket. That's all I'm trying to get done.
Yes, sir.
All right, so apparently we're not going to do anything on this one either. So the defendant's continued in custody out at low risk on $15,000 surety bond. Soon as as it stands right now, do you have a date for a Zoom where you can Zoom with him, Mr. Davidson?
Well, I was told I was going to be able to Zoom at noon, but I was waiting for the invitation. I did not receive an invitation.
Well, okay, here's what we'll do. I'm going to tell them to call out there right now and call you with an invitation or email you with an invitation. Obviously, the defendant's available because we need to get this case just like the other two. We need to get it moving. We're going to recess. The defendant's continued in custody on the $15,000 surety bond, and I'm going to step out of here, walk out there and talk to Tabitha, and she's calling the jail, and I'll tell her to call you and tell you when you set up to Zoom with him at the low risk, Mr. Davidson.
Thank you, Your Honor.
We're in recess on this case too. On the call. All right, court's calling by Zoom. Yeah.
Looks like we're still waiting on defendant and judge.
Awesome. That's fine.
Can we do the one? Oh,
All right, we're on the record in cause number 241-1153-20, State versus Timothy Phillips, charged driving while intoxicated, third or more. First paragraph of the indictment alleges the offense of operating motor vehicle at public place while intoxicated. Second paragraph has allegations of 2 prior convictions for operating a motor vehicle while intoxicated. And then the third paragraph alleges a felony conviction in the 114th District Court, 1st of June 2016, felony offense driving while intoxicated, third or more. So that's the indictment. If the second paragraph is proven, it's 2 to 10. And then third degree, and then of course, if the third paragraph and last enhancement paragraph is proven, it's 2 to 20. All right, I don't see any plea papers in the file again. I'm not sure what we're doing, but here I guess we'll go through the same deal on this one. Mr. Timothy Phillips, the defendant's present before the court. Is there a trial setting on this case, or we're waiting to see whether or not it's a plea?
Judge, maybe I can shorten this. I was appointed 5 days ago. So
Okay.
I have 5 days ago.
Okay.
I have not had time to meet with Mr. Phillips. He's
Okay.
out at low risk. I will try to meet with him as soon as possible. We thought we might be able to take care of this because he was sentenced to TDC time in another county. But I'm going to need that additional time to talk with him. So if we can have that October 19th day, I think we'll be able to resolve this.
Where was he sentenced to the pen out of? What county?
Mr. Phillips, what county?
Cherokee County.
Cherokee County.
Right down the road.
Yes, sir.
What was that? Do you know what that was for, Mr. Davidson? I don't want to be asking the defendant.
I believe it was for 6 years on a DWI. Is that correct, Mr. Phillips?
No, sir. It was an assault.
Oh, I'm sorry, an assault. What time did you get?
6 years.
6 years on an assault.
All right, well, let me give you looks like if this is what did you say, Mr. Davidson? I think, what'd you say right at the first?
I said that I was appointed to represent Mr. Phillips 5 days ago.
Okay, that's good. Now you recognize you are on the record. So, Mr. Phillips, you know Mr. Don Davidson has been appointed to represent you since you're indigent and unable to hire your own attorney. Do you understand that?
Yes, sir.
Looks like on September the 1st, 2021, you signed a pauper's oath. Looks like an indictment was returned on July the 23rd, 2020.
That's correct, Your Honor.
All right. Is Mr. Phillips downtown or at low risk?
Low risk.
Well, obviously, the last entry was the September the 2nd, 2021. It shows an order appointing an attorney. September 1st was the pauper's oath.
That's correct. That's when Mr. Davidson got appointed last week after Mr. Phillips was benched here from Cherokee County.
Okay. All right, so does Mr. Davidson have the discovery?
Yes, sir, I do.
Have you conveyed an offer to Mr. Davidson? Obviously, you hadn't had time to talk to the defendant about it.
I have, Your Honor.
What's the offer?
The offer is 16 years.
All right, so the offer on the record by Ms. Anderson is 16 years. That'd be in TDC with credit. Of course, it'd be running concurrent with whatever sentence he got out of Cherokee County. What sentence did he get out of Cherokee County?
He
6
got
years.
6 years.
He what?
He took 6 years in Cherokee County.
Okay, so if the defendant pleads guilty and the court follows the plea agreement and assesses the 16 offered by the state, that becomes the actual plea agreement. Then it'd be the 16 years assessed here with credit for time served, or to run concurrent at the same time with the 6 years sentence out of Cherokee County for felony DWI. That's where we are. So I guess we'll just, well, we've set it, bond on is $100,000 bond because it's got those 3 priors alleged. So what do you want to do, Ms. Anderson?
Well, Your Honor, I really don't think Mr. Davidson's had time to go over the discovery or talk to his client. So we're willing to hold his offer open. It's a high offer and it's not going to get much better. So he probably needs time to speak with him.
Yeah, I don't expect Mr. Davidson to know today whether or not the defendant's going to accept the offer. I just was trying to get some idea. Maybe Mr. Davidson could give me some idea of when we need to set this, when the next setting needs to be. So Mr. Phillips doesn't end up sitting in jail because, we don't have another setting on the case. So what do you suggest, Mr. Davidson?
October 19th at 9:30, Your Honor.
That's a Tuesday, Judge.
I'm sorry?
That's Tuesday, October 19th at 9:30.
That sounds like Tuesday, October the 19th. If I got the date right, Tuesday, October 19th at 9:30. That would be to determine whether or not, in other words, if there's a plea agreement reached prior to that date and y'all have the plea papers signed, ready to go, I'll take the plea and follow the plea agreement on that date. It's not a plea on that date, which appears that would give everyone plenty of time. It will go over on the next available trial docket. Defendants continued in custody on this one under that $100,000 surety bond. It's not the amount of bonds not on the docket sheet. I'm going to have to look at $100,000 surety bond. Anything else, Mr. Davidson?
No, Your Honor.
All right, we're in recess to that date. Just put on the record by Tabitha, my court coordinator. The defendant will be back on Zoom at that date, determine whether or not the defense is going to accept or reject the state's offer of 16 years TDC with credit, which would be ordered to run concurrent at the same time for the 6-year sentence out of Cherokee County. All right, anything else, Ms. Anderson, on this one?
No, sir.
Anything else, Ms. Roberson?
No, Your Honor.
I'm sorry. I just had Mr. Roberson the other day, and he's still on my mind. I meant, so although you may have missed it, I said anything further, Mr. Roberson. I understand why you didn't say anything. Anything further, Mr. Davidson?
No, Your Honor.
All right, we're in recess to finish continuing custody. We do have that date now by which we'll know whether or not it's going to be, if it's a plea, it'll be a plea by that date. Otherwise, it'll go on the trial docket. Court won't accept a plea after that date. Anything else?
No, Your Honor.
All right, we're in recess.
Will you put the deputy back on? Okay.
I'm thinking October 19th, October 19th, October 19th. Anybody have any?
Yes, sir. What is your name?
To do this again.
The defendant. What is your name?
Sanford.
What?
Brian.
Sanford.
Brian. B-R-I-A-N.
Sanford.
Yes.
It's Brian Sanford.
Okay. Will you ask the deputy to step over to the computer, please?
Do what?
Deputy, this lady over here wants to talk to you.
Yes, ma'am.
Hey, did y'all get Jeffrey Jansen?
Jeffrey Jansen is under quarantine at the moment.
He is. Okay.
No, excuse me. I'm sorry. Yes, he is right here.
He is here.
Yes, ma'am.
Okay, perfect. That's all I needed. Thank you.
Yes, ma'am.
Good idea. I would go ahead and go put some in.
Taken one has to be transferred somewhere.
Hmm.
It's just you and me.
All right, we're on the record in by Zoom. Calls number. That was number 241-1131-21, State versus Brian Sanford. Present for the court from Zoom, by Zoom from Low Rest, I think it is. Mr. Davidson, his attorney, is present by Zoom. Ms. Anderson, state's prosecutor, is present by Zoom. Of course, probation officer is present by Zoom. 241-1131-21, Brian, State versus Brian Sanford, possession of controlled substance less than a gram, state jail felony. Cause number 241-1336-21. Charged by indictment on all possession of firearm by a felon, third-degree felony as alleged in the indictment. Mr. Davidson, you want to waive the reading formal presentation of all the formalities, and is his name set forth correctly?
Yes, Your Honor, we'll waive the reading of the indictment. His name is set forth correctly. We have an agreed recommendation on punishment.
All right, Mr. Sanford, I have to swear you in. Just raise your right hand. Can you hear me?
Yes, I can, Your Honor.
Do you solemnly swear your testimony will be the truth, the whole truth, nothing but the truth, so help you God?
Absolutely.
All right, Mr. Sanford, two indictments. First one, 241, it's on the screen. 241-1131-21, charging state jail felony, possession of controlled substance. Do you understand all the allegations in the indictment and the full range of sentencing, which is a state jail felony, 180 days up to 2 years in a state jail facility?
Yes, sir.
All right, going to the next one, 241-1136-21, State versus Brian Sanford. It's for, as you can see, and as you already know, unlawful possession of a firearm by a felon, third-degree felony as alleged in the indictment. And you have a set of plea documents on this one. Also, your plea agreement on this one shows if you plead guilty, state's going to recommend 3 years in TDC. If you plead guilty on the other one, the possession less than a gram, of course, state's recommended 9 months. Are those your plea agreements?
Yes, sir.
Also on 241-1136-21, just for the record, that one of the provisions on the plea agreement is if you plead guilty to this unlawful possession of a firearm by a felon, the state's going to recommend 3 years TDC with credit. Also, the state will decline DA number 21-02521 for theft of a firearm and decline 21-02523 for unlawfully carrying a weapon. Is that your plea agreement in that one, Mr. Sanford?
That appears to be correct, sir.
All right. The other one's 9 months, possession of state jail, possession of controlled substance less than a gram, state jail facility offense. That shows to be 9 months with credit in that one. Is that correct?
Yes, sir.
All right, then, of course, if you go ahead and plead guilty, the court receives and accepts both your pleas of guilty. The court follows the state's recommendations. The court would assess those sentences in each case, and that ought to be run. They would order to run concurrent or at the same time. You understand all that, Mr. Sanford?
Yes, sir.
All right, here are the plea documents. I have them in both cases. They're different. Obviously, as I've already said, your recommendation and your agreement on the possession of controlled substance less than a gram is 9 months in a state jail facility with credit for time served. You'd be able to pay $180 to DPS lab for the analysis of the controlled substance. That is your plea on that one?
Pay $180.
Yeah. Sure, let me explain that to you. Your sentence is 9 months in a state jail facility with credit for time served on that one. Part of that sentence is to pay $180 to the Department of Public Safety for the lab fee in the analysis of the controlled substance in the case, just standard provision.
Okay, and that is payable when?
Well, that'll be payable sometime along the road, like sometime normally, because you're going to be, I don't know how much, when you get sent to, you'll be sent to TDC because the sentences are running concurrent. So you're ordered to pay it, and then in all likelihood, you're going to have to pay it when you get released from TDC. That's the bottom line.
All righty then.
Okay. All right. So you do understand all the allegations, the charge in the indictment, a full range of sentencing for possession of controlled substance, and in the other indictment, unlawful possession of a firearm by a felon. Is that correct?
Yes, sir.
All right. We've got these plea documents we have in each cause number. I'll just identify the plea document we have in each cause number. We've already been over the plea agreements. We also have the acknowledgement of admonishments in each case. That is your signature down there on the line above where it says defendant, is it not, Mr. Sanford?
Yeah, that's pretty good representation of it, sir.
Yeah, I understand that. I just have to ask you for the record. The record reflect the defendant's signed all the plea documents. Let me be sure, Mr. Sanford, this won't take long once we get to going. Just raise your right hand. I want to be sure I've got something in your oath. Do you solemnly swear the testimony you'll give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And that when you signed and swore to these documents, you were swearing to these documents freely, intelligently, knowingly, and voluntarily.
Yes, sir.
All right, here we go. Same, it's just each case has an acknowledgement of admonishments, shows in full range of sentencing for the possession of controlled substance, not less than 100 days, not less than 180 days, up to 2 years. Of course, you're in a state jail facility. Your plea agreement's for 9 months with credit and payment of restitution, which I'm going to follow. And then we'll just go ahead and get them done one at a time. In the acknowledgement of admonishments, there are a total of 7 admonishments. You signed along with your attorney below the 7th one. Do you understand all 7 admonishments?
Didn't have time to read them, Judge, but I'm sure that if I've got the paperwork, I would understand them.
Well, okay, that's probably a pretty good analysis of it, but I have to be sure before I take your plea. These acknowledgements, you can see the 7th one up on the screen, but there's a total of 7. You and Mr. Davidson have signed there below the 7th, but did you go over all these admonishments with Mr. Davidson so he explained each one of these admonishments to you?
We didn't really hit them like we should have, but that's quite all right. I've been through this before, Your Honor, and I'm very well aware of procedural law. So I'm sure that I've read them once or twice before. So go ahead, sir. Please continue.
Well, I tell you what, it's sort of that. I'm sure of this and I'm sure of that. Problem is, I have to be sure the record is complete before I accept your pleas of guilty, find you guilty for each offense, then assess you time in state jail and time in TDC is 3 years. So in other words, do you need some more time to go over these admonishments with Mr. Davidson? I have to be sure they're the same in each case except for the range of sentencing.
No, that's fine, sir. You go ahead.
All right. Do you understand them? It's no problem to give you time to go back over them with Mr. Davidson because I have to be sure these admonishments are important in both cases. So I have to be sure that you understand all 9 admonishments. Right now, I'm not sure you do understand all 7 admonishments. They're the same in each case, except for the range of sentences. So I don't want to go forward until you're able to tell me that you did go over these with Mr. Davidson. He explained them to you and you understand them because they're important.
Okay. Mr. Davidson, would you please explain to me what these admonishments are?
So here's what we're going to do. We'll just let you and Mr. Davidson go out into what we call the breakout room, whatever that is. We do it occasionally. Mr. Davidson will go over these, each one of these, total in each case, 7 admonishments. Then when you come back on the screen with Mr. Davidson, and if you can tell me then you've gone over them with Mr. Davidson, he's explained them to you, then you understand all 7 admonishments will go forward on the plate. So go ahead and explain them to him, Mr. Davidson. We're going off the air on the plea right now and let you get with Mr. Sanford. Be sure he understands all the other papers too, Mr. Davidson. Well, I've still got Mr. Sanford on there. I guess Mr. Davidson's going to get there. He goes. Okay, he's gone now.
Yep. There you go, Dawn.
Something else. All right, we're back on the record by Zoom and cause number 241-1131-21. State versus Brian Sanford before the court by Zoom on indictment charge of possession of controlled substance less than a gram state jail felony with his attorney, Mr. Don Davidson. Also, Ms. Anderson, state's attorney, is present by Zoom along with the court's probation officer. Also on the record, back on the record in 241-1136-21, State versus Brian Sanford before the court on an indictment charge of unlawful possession of a firearm by a felon. All right, to pick back up, Mr. Sanford, can you hear me?
Yes, sir, I can.
All right, now to pick back up and try to get on through this, looking first of all on the possession of a controlled substance less than a gram. You understand if you plead guilty, the court's going to follow the plea agreement, assess your sentence at 9 months in a state jail facility with credit for time served.
Yes, sir.
All right, there's an acknowledgement of admonishments. It has a total of 7 admonishments, explanations in it. Your signature and Mr. Davidson's are below the 7th one. Do you understand all 7 admonishments?
Yes, sir.
Next document's waiver of trial by jury. Do you understand you're waiving and giving up your right to a jury trial?
Yes, sir.
Do you understand you're waiving confrontation with witnesses and agreeing to stipulate testimony?
Yes, sir.
You understand your stipulation of evidence in 1131-21. That's a written judicial confession under oath by you to the allegations of the charge and the indictment for possession of a controlled substance, meth. You understand that?
Yes, sir.
The next document's an agreement to stipulate testimony. The next document you have signed along with your attorney is a waiver giving up your right to file a motion for new trial, waiver giving up your right to appeal. Do you understand that?
Yes, sir.
And you've already waived the pre-sentence investigation, and also you've signed you and Mr. Davidson both signed in both cases a trial court certification of your rights to appeal. They both show, which is correct, these are plea bargain cases, and then you have no right to appeal. Now, I have the same set of plea documents over in the unlawful possession of a firearm by a felon, the 3rd-degree felony in 241-1136-21. You've also signed and sworn to all of those. Your plea agreement, 3 years to do with credit for time served. The state will decline a theft of firearm case and an unlawfully carrying a weapon case as part of your plea agreement. Is that your plea agreement, 3 to do with credit? Is that it?
Yes, sir.
You've signed also in this case as the other one, but they're different. The acknowledgement of admonishments, you understand full range of sentencing, 2 to 10, fine of up to 10,000, 7 admonishments, their explanations. You understand all of them?
Yes, sir.
This one also, you're waiving, giving up your right to trial by jury. You understand that?
Yes, sir.
You're waiving confrontation with witnesses. You signed and now sworn to a stipulation of evidence. You understand that's a written judicial confession under oath by you to the offense of unlawful possession of a firearm by a felon, 3rd-degree felony.
Yes, sir.
Then you signed, as in the other case, agreements to stipulate, these are all signed by your attorney also, agreement to stipulate testimony. You signed a document like you did in the other case, waiving, giving up your right to appeal, waive the pre-sentence investigation. There's a trial court certification like in the other one showing this is a plea bargain case and you have no right to appeal. Do you understand that?
Yes, sir.
Right, understanding all of these plea documents, your plea agreements, and understanding all of the allegations in each indictment, 1131-21 for possession of a controlled substance less than a gram and 241-1136-21, 3rd-degree unlawful possession of a firearm by a felon. Do you still wish to go forward on your plea of guilty to the indictments in each case without a jury?
Yes, sir.
These questions I'm getting ready to ask apply to your pleas to each indictment, so I'm not going to be asking them twice. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Yeah, I have to ask you. Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or substances in your system?
No, sir. I've been locked up for 6 months.
Well, that pretty well should take care of it. Have you ever been confined in a mental institution or under psychiatric treatment?
No.
All right. Do you understand everything you're doing by Zoom in court today?
Yes.
Have you been over everything about the facts of these cases and everything you're doing in court today and all your plea documents with your attorney, Mr. Don Davidson?
Yes.
Is it competent, Mr. Davidson?
Is, Your Honor.
Evidence of incompetence, Ms. Anderson.
No, sir.
All right, court notes states counsel signed her consent to approve the waiver of trial by jury in both cases and all the other waivers in each case signed or sworn to by the defendant. All right, now in each one of these cases, Mr. Sanford, you do understand all the allegations in each indictment, the full range of sentencing for each case, or plea documents on each case, is that correct?
Yes, sir.
All right, in cause number 241-1131-21, what is your plea today to the indictment charging you with possession of a controlled substance less than a gram?
Guilty.
In cause number 241-1136-21, what is your plea today to the offense charged in the indictment for unlawful possession of a firearm by a felon, a third-degree felon?
Guilty.
Are you entering your plea of guilty to each indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way or promise you anything or coerce you to plead guilty?
No.
Are you entering your pleas of guilty to each indictment today freely, intelligently, knowingly, voluntarily, because you committed the offense charged in each indictment?
Yes.
Are you entering your plea of guilty to either indictment today as a result of any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No.
Court does receive and accept your pleas of guilty to the indictments in each cause number, Mr. Sanford. What do you have, Ms. Anderson?
In each case, Your Honor, we'd offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance document.
No objection.
No objection. In each case, court approves, admits into evidence, states 1, all the plea documents, states 2, the signed and sworn to stipulations of evidence, states 3, discovery compliance. Court having admitted into evidence, in each case, states exhibits 1, 2, and 3, the court does find the defendant's waiver of his rights, execution of all the documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in each case was entered by the defendant to the indictment in each case freely, intelligently, knowingly, and voluntarily. The court receives and accepts the defendant's plea of guilty to each indictment, finding the pleas of guilty were entered freely, intelligently, knowingly, and voluntarily, and fully supported in each cause number by the exhibits submitted into evidence in each cause number. The court does find the defendant guilty of the offense of possession of controlled substance, a state jail felony, in indictment 241-1131-21. The court does find the defendant guilty of the offense of unlawful possession of a firearm by a felon in indictment 241-1136-21, finding both pleas of guilty were entered freely, intelligently, knowingly, and voluntarily, supported by the evidence in the record. What else, Ms. Anderson?
Your Honor, the only other thing we have is to offer states 4 a single electronic copy of the written discovery in each case.
No objection.
States 4, all the offense investigative reports, DPS lab report, those are all admitted into evidence with no objection. The court in each cause number, having received and accepted the defendant's pleas of guilty to the offense alleged in the indictment in each cause number, the court does formally pronounce sentence. The court does find the defendant guilty of the offense alleged against him by the state in each indictment, and the court on each indictment follows the plea agreements and the recommendations of the state. In cause number 241-1131-21, the court does assess the sentence at 9 months in a state jail facility with credit for time served. $180 restitution is ordered to DPS. In cause number 241-1136-21, court having received and accepted the defendant's plea of guilty, finding the defendant guilty of the offense of unlawful possession of a firearm by a felon. Court follows the plea agreement, assesses the sentence at 3 years in the Texas Department of Corrections Institutional Division. Court further orders the sentence assessed by the court following the plea agreements in each cause number are ordered to run concurrent or at the same time with credit for time served. Waivers of appeal are approved and accepted by the court. Mr. Sanford, you satisfied with Mr. Don Davidson, your court-appointed attorney? That's the last question I have.
Yeah.
All right. Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Davidson?
No, Your Honor.
We're in recess. Defendant, Mr. Sanford, is continued to custody of the sheriff till he can be transported to the Texas Department of Corrections Institutional Division. Serve the sentence is assessed by the court in each cause number. Each sentence are to run concurrent or at the same time with credit for time served. We're in recess.
Mr. Davidson,
Yes, Mr. Sanford.
how much good time do I have on this right here?
let me get you a copy of the judgment. When the judge has to sign it first. And so I'll get you that, and I'll get you the time calculation sheet too, okay?
Thank you, sir.
You bet. Hang in there.
Am I done?
What time are you supposed to report?
Let them know that we need Leon Bradford.
You can report and then come back. I mean,
Am I done?
oh yeah, you're done.
Let them know that we need Bradford.
Oh, Bradford. Oh, this will be fun. This is the last one, I think. And then we do your own. That'll give me time to go over with you while she's reporting, and then you come back here and then.
Or if you want to, I can just wait until my probation officer says.
Yeah, but I mean, it won't take that long. Yeah, you just go and come back.
I've been trying to have, she had me like this about an hour. She had me waiting, was grabbing her tea, then she had me talking.
Oh, excuse me.
What?
I have returned at 30.
Oh, she's 3:15 and you're 3:30?
Oh, yeah, we have a lot, all of them, like most of them go around the same.
Boom.
time, like,
Okay,
because, it's a lot of probation officers, so they all take me to deeper.
hang on one second. Sir,
Yes,
what's your name?
Jeff Jansen.
Oh, okay, got you.
Hang on a minute.
And when did you you were out of county, right?
Yes, I was in Franklin County,
Okay, when did you get back from Franklin?
yesterday afternoon.
Okay, there we go. Gotcha.
All right, court of call cause number 241-1063-21, State versus Jeffrey Jansen. Charge of offense, possession of controlled substance less than a gram. He's present by Zoom before the court with his attorney, Mr. Court appointed, Mr. Don Davidson, Ms. Anderson, State's counsel is present. Indictment alleges the offense of possession of controlled substance more than 1 gram, but less than 4 grams. In the first paragraph, of course, if proven, that would be a third-degree felony carrying a sentencing range of not less than 2 to more than 10 years in TDC. The fine may be assessed at up to $10,000. However, the second paragraph of the indictment alleges the defendant has a prior felony conviction for the offense of possession of a controlled substance. If proven, or if the defendant pleads true to that, then it would increase the sentencing range from a third degree up to a second degree on the indictment, not less than 2 to more than 20 years in TDC. Fine may be assessed at up to $10,000. All right, Ms. Anderson, what do we have here? Like I said, Jeffrey Jansen's on the screen by Zoom.
Your Honor, the offer for Mr. Jansen is 10 years confinement in the institutional division.
I'm sorry, would you say that again, Ms. Anderson?
The offer for Mr. Jansen is 10 years confinement in prison.
All right, the offer from the state's 10 years confinement in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served on the plea, if there ever is a plea. Mr. Davidson?
Judge, we're asking for that October 19th date. For the record, Mr. Jansen has been kept in the Franklin County Jail because of, I guess, overcrowding at the jail. And so I have not had a chance to meet with him, go over his indictment, go over the discovery, go over the plea offer, go over anything with him, because he just returned from Franklin County yesterday.
Okay. So what is, Ms. Anderson, what would be the next date? Mr. Davidson, I think Mr. Davidson was just requesting a new date. No, it's obviously we're not going to be able to proceed today. Defendant's going to be continued in custody. Well, apparently Mr. Davidson is not even sure whether or not this is going to be a plea, because the defendant had been incarcerated in another facility and just got back yesterday, I think Mr. Davidson said. So let me see what date we need to move this to.
Judge, we can move this to the Tuesday, October 19th at 9:30.
Would that'd be a plea docket tab?
Yes, sir.
Tuesday, October the 19th. Tabitha, is that correct?
Yes, sir.
Tuesday, October the 19th at 9:30. That'll be a plea docket. So Mr. Davidson, and of course, Ms. Anderson, and so you'll understand, Mr. Jansen, if it is going to be a plea agreement, if the defendant's going to enter a plea of guilty, there's a plea agreement, the court will follow it, then that would have to be done, obviously, in time for the paperwork to be done before that date that Tabitha just gave us. The defendant's on a $40,000 surety bond on possession, enhanced up from a third degree possession of a controlled substance. First paragraph charges third degree enhanced up. It becomes a range of sentencing if the enhancement's proven to 2 to 20. All right. So anything else today, Ms. Anderson?
No, sir.
I take it obviously there wouldn't be anything else today, Mr. Davidson, but the defendant just getting back.
Correct, Your Honor.
Let me go ahead and Tabitha, so what's our next setting on it? By then, Mr. Davidson would know whether or not it's going to be a plea or a trial.
It is Tuesday, October the 19th at 9:30.
The court sets this case for Tuesday, October the 19th at 9:30. The case will be called on that date, looks like, unless it changes by Zoom. And on that date, the court will obviously need an answer from the state defense about whether or not this case is going to be a plea or a trial. If it is going to be a plea, then there should be plea papers before the court on that October 19th date and time so the court can go ahead and take the plea at that time. There wouldn't be any reason to have to reset it again. Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Davidson?
No, Your Honor.
All right, the defendant, Mr. Jansen, back here now for the court by Zoom today, back in Smith County Jail. He's continued in custody on a $40,000 surety bond. We're in recess until the date stated by the court, when either by Zoom or in person, we'll be back up on the case. Counsel, let me ask you this. If it is going to be a plea, obviously, that's basically a plea date you're getting. So if it is going to be a plea, I'll need the plea papers on that date. If it's not going to be a plea, I won't take a plea agreement out after that date. Do you have the date, Mr. Davidson?
October 19th at 9:30, Your Honor.
That's the way we're going to try to be real careful about putting that on the record on these. October the 19th at 9:30?
Yes, sir.
The court will take the plea on that day. If there's no plea in place on that date, the court will not take a plea agreement on the case, and defendant would be then continued in custody on his $40,000 surety bond until we reach it on the trial docket. All right, we're in recess today. Defendant's continued in jail in custody on the $40,000 surety bond. We're in recess.
Mr. Jansen, can you tell him we need Mr. Bradford?
Yeah, Mr. Davidson, when are we going to talk?
As soon as I can get an appointment at the jail.
Where?
I need to get an appointment at the jail.
At Franklin County? Or-
No, you're not in Franklin County, are you?
No, I thought I was going back there though.
No, you're not going back. You're staying here.
Oh, okay.
And do you have something pending there?
No, they put me over there because they're overloaded here.
Right.
And I was talking to the deputies here and they were going to bring me back up there in the next couple of days.
Well, I'm going to ask that they don't do that. I hope they don't do that, because otherwise it's going to be really difficult to talk with you. But I can't control it. I'll just ask that they not do that.
Okay, well, I need to speak to you as soon as possible.
Okay, I'll try to get there as fast as I can.
Well, he'll still be there in the morning.
I hope so.
Oh yeah, he'll be there in the morning. If you get on over and talk to him in the morning.
Okay.
Well, you'll find out what you need to know. I would think our court doesn't have any course control over when they may bench him back to the other county, as you know, Mr. Bates.
Right.
I might want to get on over there and talk to him, but about the case, see whether or not it's going to be a plea. As soon as you can, obviously, once he gets sent back, we're not going to make any progress on his case either way. So
I'll try to get over there this afternoon if I can, Your Honor.
All right, good deal, Mr. Davidson. Looks like Looks like we're on down to Leon Bradford. That's not getting confused.
Yeah.
Okay, the
He-
file I just got to Leon Bradford driving while intoxicated. 30.
He's not here.
That answers my question. Thank you.
Where's the
He's
Where's
in-
the deputy at?
Right here. Let me let you talk to him.
Good deal. Thank you.
Yes,
Do we not have Bradford?
Bradford is under quarantine at the moment.
Okay. All right, then looks like we're done, right?
Yes, ma'am, that should be
All
it.
right, thank you.
Did we have Nicholas Ford?
What happened to Bradford?
Bradford is under
in-
quarantine.
Oh, quarantine. Okay.
Oh, Nicholas Ford is not in jail?
Should not be in jail, negative.
You want to get that while I'm pondering in my head?
That's news to me.
Okay, we're done with,
So tomorrow
Okay.
afternoon.
Can we do the out of jails?
yes.
Okay, come on. Just bring your chair. Pull it right here.
Elizabeth, I do not have Nicholas Ford in jail.
You're right. He's
That's probably
totally worked out.
for anybody
I
else.
don't suppose he's there with you, Don.
I've got 3, and I don't believe any of them is
Do you
Nicholas.
wanna-
Okay, who is this, Dawn?
Well, do you
This
want to
is
shoot?
Miss
for-
Curtis. There you are. We're just asking for more time so we can talk. Okay?
All right, looks like we're on the record, I think, in cause number 241-1058-21, State versus Kadasha Nicole Curtis on an indictment charging the evading arrest or detention with in a motor vehicle. Apparently, she's present before the court by Zoom with Mr. Davidson, wherever he is. State's counsel, Ms. Anderson's present from her office. Of course, probation officer Marcella's present. What have you got on this one, Ms. Anderson?
Your Honor, we're set today for Ms. Curtis' plea docket agreement date, and the current offer is 4 years confinement in the institutional division.
All right, the indictment charging arrest for evading arrest or detention with a motor vehicle, 3rd-degree felony. State's offer is if she pleads guilty, the state's going to recommend 4 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served. So we need to know whether or not she's going to plead, when do the plea as soon as we can, or whether or not she'll go over onto a trial docket. If she goes under a trial docket, of course, as you know, the state's not going to take it, offer a plea, and the court's not going to have, not be able to accept one. So what are we going to do?
Judge, I'm asking for that October 19th day. I have not had a chance to meet with Miss Curtis. She's obviously here now. She has to go and report to pretrial, which she's been doing. I believe she may have actually been in another court. I don't think I was appointed all that long ago. And I have not had a chance to go over the discovery or the plea offer or the indictment with her. And if we can have that October 19th day, I think we can make a meaningful announcement on that date.
Okay, I'm sorry, where has she been? Ms.
She's
Anderson?
reporting to pretrial. I just don't think I was appointed all that long ago. I have not had an opportunity to meet with her.
Well, I see what you're
I
saying.
didn't know anything either. I didn't just.
No, let him finish. Let him talk.
You know, let's see, I don't know when you were appointed, Mr. Davidson. I don't see it right off.
August 4th,
Tabitha
or not
Kelly.
discovery on August 4th. I don't know when his appointment was. The discovery was provided August 4th.
Well, if it was obviously provided to Mr. Davidson, so obviously as of August 4th, he had been appointed.
Right.
Well,
I think
I don't have any.
the,
Well, the defendant's under a $25,000, she's on a $25,000 surety bond. She appears to be out on that bond, sitting by Mr. Davidson somewhere.
right. But this is my first time meeting her. So if I can have that October 19th day, I can go over that with her. She can go report to pretrial. Then she's coming back over here and we're going to go over everything today.
All right, so Ms. Anderson, that's suitable with you. So if October 19th is a plea docket, correct?
Correct.
Yes,
All right, defendant's on bond. Although I don't see the bond amount on the docket sheet. Let's see, let me see.
I believe you said it was $25,000, Your Honor.
25,000, when I look at the indictment, of course, on the back of the indictment, it's $25,000 surety bond. So Ms. Curtis, you're on a $25,000 surety bond. Mr. David said you'd been reporting pretrial. Court's probation officer Marcella's on the screen. What can you tell her, Marcella, to be sure she knows what she needs to do in between now and, I'm sorry, I didn't have a place to write it down. What's her next date, Ms. Anderson?
October 19th, Your Honor.
All right, let me tell you about that, Ms. Curtis. Be sure you understand that. Now, one of the conditions of your bond, you're out on a $25,000 bond. One of those conditions now becomes for you to be back before the court, either in person in the courtroom or on Zoom with Mr. Davidson on October 19th. Anyone know what day of the week that is, October 19th?
Tuesday.
All right, so Tuesday, October the 19th is the plea deadline. So we'll be back in person in the courtroom, defendants on bond. So we're going to either be in a courtroom or on Zoom. And on Tuesday, October the 19th, at what time, Ms. Anderson?
I believe it's 9:30, Your Honor.
I believe it is too. So let me be sure, because this is all being recorded by my court reporter, Ms. Curtis. What I want you to understand is you're on this $25,000 bond on this third-degree felony charged by an indictment evading arrest or detention with a motor vehicle. One of your conditions of that $25,000 bond is for you to be back before this court, either in person in the courtroom or by Zoom with Mr. Davidson. He will be in the courtroom with you, or he'll be back on Zoom with you on Tuesday, October the 19th at 9:30. What I want to be sure you understand, Ms. Curtis, that now becomes a condition of your $25,000 bond. So if and I don't have any reason to think you won't be here, you're here today, but if you're not back before the court by Zoom or in the courtroom on Tuesday, October the 19th, and Mr. Davidson has that date written down at 9:30, the court would forfeit your $25,000 bond, likely increase it, triple it to $75,000, and issue an alias capias warrant for your arrest. You understand all that?
Yes, sir.
You understand all that?
Yes, sir.
All right, Marcel, do you have her next reporting date?
Yes, Your Honor. She is scheduled to report to pretrial officer Miss Karina Acevedo, September the 8th at 3:30.
Mr. Davidson will write that date down for you, Ms. Curtis, September the 8th at 9:30, and give you that date on a piece of paper, because you have to be in your officers down at the probation department to meet with your bond supervisor on that date, which Mr. Davidson is going to write down for you. Do you understand all that?
Yes, sir. I thought it was today, but it's tomorrow.
Well, okay, it's up to you. I mean, Marcel, you want her to come on down there? I don't know where, she's pretty close. She's sitting there with Mr. Davidson. He's never far away.
Yes, Your Honor, and I'll let her officer know she's on her way.
All right, that's a good deal then, Ms. Curtis. Just head on down and get your reporting done today. And your reporting, drug testing, or whatever else the probation officer supervising you needs to get done. We'll get that done today, and then you're set on the plea docket to see whether or not this is going to be a plea agreement or a trial on Tuesday, October the 19th at 9:30. So it's a condition of that $25,000 bond, as I probably said 4 times, for you to be back before the court with Mr. Davidson on Tuesday, October the 19th at 9:30. You understand all that?
Yes, sir.
All right, report on down to my probation officer. Get them that way. You report on down now, and then we're in recess till that date set for the plea by the court.
Okay.
October the 19th, Tuesday, October 19th at 9:30. Do you understand all this, Ms. Curtis?
Yes, sir. She does. I told her to go on because she was supposed to be there at 3:15.
All right, doesn't sound like that'll be a problem. We're in recess on this case.
Okay, Don, which one is this?
Brian Vaughn.
Thank you.
All right, we're continuing on the record by Zoom on cause number 2410471-21 State versus Brian Vaughn, present before court by Zoom with his attorney, Mr. Don Davidson, on possession of controlled substance less than a gram. Bond is set at $30,000 surety bond. Ms. Anderson is present representing the state. Okay, what have we got here, Ms. Anderson?
Your Honor, Mr. Vaughn was set for plea docket today. Ms. Autry had worked out an offer with Mr. Davidson, but this morning when I reviewed it and reviewed the case file, I revoked that offer and made a new offer. So we're going to need time for Mr. Davidson to talk to his client because it went from being a probation offer to a time offer. And as I said, Mr. Davidson just got that new offer this morning.
Just for the record, what's the offer now?
I don't know that I even gave him a number. I
That's okay. I understand what you're saying. As it stands now,
told him that I would not honor the probation offer.
Right, the earlier offer made by Ms. Autry, that's been revoked. So you're working on getting a new offer to Mr. Davidson along with, of course, Mr. Vaughn. So what's our new date?
October 19th.
I'm sorry, that was a bad question. What's our new date, Ms. Anderson? You're up top.
I think Mr. Davidson's asking for October 19th if Ms. Freeman still has room.
Well, that's probably a good date because he'll be here on about 40 other cases. So we'll set this one for October the 19th. At what time are all those cases set for?
9:30.
All right, Mr. Vaughn, you're continued on your $30,000 surety bond, but you're ordered by the court to appear back before the court with Mr. Davidson on that date and time. Do you understand the date and time?
Yes, sir.
Okay, what's the date and time?
So October 19th.
Right, October 19th at 9:30. That'll either be by Zoom or it'll be in court. Now, if there's not, what'll happen is if there's not a plea agreement worked out on this case, third-degree felony, if there's not a plea agreement worked out on this case between you, Mr. Davidson, and the state, I won't accept a plea agreement after this next date. Then it'll just go on the trial docket. Do you understand all that?
Yes, sir.
Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Davis?
No, Your Honor.
All right, we're in recess, and Mr. Vaughn is a condition of his bonds ordered back before the court by Zoom or in person with Mr. Davidson on the date previously set by the court today. We're in recess.
Okay.
All right, we're on the record by Zoom and cause number 241-1064-21. State versus Rachelle Jansen, present for the court by Zoom with her attorney, Mr. Don Davidson. Rachelle Jansen being present, Ms. Anderson present for the state. This is a 1064-21. Indictment charging driving while intoxicated. Looks like third-degree felony, primary offense charged in the first paragraph, 2 priors alleged in the second. So it looks like a driving while intoxicated, third-degree felony, 2 to 10. All right, the defendant is out on a $75,000 bond. Ms. Rachelle Jansen, who made your bond?
Who made my bond?
Who was the bondsman?
The bondsman?
Yes.
The name of the company.
Yeah.
Legino's.
Longino's.
Longino, okay. All right, what have we got on this one, Ms. Anderson?
Your Honor, Ms. Johnson has a probation offer, 10 years probated for an 8-year term.
That's correct, Your Honor. I just need I just need some additional time to go over the discovery with her. And I need to be able to show her the video off of the DWI stop and some other things. I think we can resolve it if we can get that October 19th date, please.
October the 19th. What time?
9:30.
Okay with you, Ms. Anderson?
Yes, sir.
All right, Ms. Johnson, to be sure you understand it now, that October 19th date, do either one of y'all know what day of the week that is?
Tuesday.
Tuesday, October the 19th at 9:30, Ms. Johnson. You have to be back before the court, hopefully in the courtroom in person, if not by Zoom as you are today. Have you got that date? It's real important.
Did you hear the date?
Yes, yes, sir.
Okay, what's the date?
October 19th, 9:30.
Tuesday, October the 19th at what time?
9:30.
I couldn't quite hear. What time, Mr. Davidson?
At 9:30 in the morning, Your Honor.
Okay, do you understand that date and time, Ms. Johnson? I couldn't hear quite what you said at the end. So the reason this is so important, you have to be back before the court on that date for the court to determine whether this is going to be a plea, a guilty plea by you on a recommendation by the state, or whether or not it'll go on the trial docket. Do you understand that?
Yes, sir.
Okay, so we'll see you back either by Zoom or in person in court. Mr. Davidson will let you know about that. Well, you're on a $75,000 surety bond now, so be sure to report as ordered in your conditions. Do your drug and alcohol testing and meet all your other conditions of bond, because if they get a bond violation report on you, that $75,000 bond will triple and a warrant will go out for your arrest, okay? You've been doing real good so far. Just keep going to the probation office, passing your test, meet all your conditions of bond, and you'll remain out on the $75,000 bond, okay, Ms. Johnson?
Yes, sir.
Is this going to be a plea or a trial? Do y'all know?
I'm going over her options with her. I'll get back with the court as soon as possible. She's supposed to report to pretrial at 3:30. So I just want to make sure she gets there.
All right, get her on the road, but would you get back with Ms. Anderson,
Yes, sir.
Mr. Davidson, as in the other cases, and let us know so we can narrow down what's going to be a plea and what's going to be a trial. You've had several cases today like everyone else. All
Yes,
right,
sir.
we're in recess. Defendant Ms. Johnson's continued on bond with all the conditions of bond. Marcella, my probation officer's on the screen, Ms. Johnson. She'll be waiting for you down at the probation department. So head on down there now. Anything else, Marcella?
No, Your Honor, nothing further.
We're in recess.
Okay.
Right here.
Yep. Yeah, come back. I'll be right here.
Okay, Judge, we're finished.
Thank you.